Hey, welcome to today's video. We're going to take a look at who enforces the DMCA. I'm Rick Chapo. I'm with DMCAagentservice.com. We provide third-party agents to website and app owners who are looking to comply with the DMCA but don't want to list their personal information online. So the DMCA, we're talking about the Digital Millennium Copyright Act. It was signed into law in 1998 by President Clinton and addresses online copyright infringement situations. So as the agent for our clients, we often receive DMCA takedown notices. These are essentially copyright infringement complaints. It's kind of our role. That's what we do. And when these complaints come in, every couple will have interesting little threats in them that are rather humorous. And these threats will say things like, we will report you to the DMCA, or are you aware the DMCA can file criminal charges against you? And the reason they're humorous is the people that are filing them obviously don't understand the DMCA. So let's be very clear. The DMCA, quote unquote, refers to a law. It does not refer to an agency. There is no agency called the DMCA. There's an agency called the IRS, and it enforces tax law. There is no equivalent with the DMCA. The Copyright Office is not charged with enforcing the DMCA. That's just not the way that this law works. It's not meant for government enforcement. It can be addressed in court cases, but there is no government agency you file a complaint with or anything of that sort. And if people reference it in a way that suggests they think there is, you should just smile because they don't know what they're talking about. So enforces, that word kind of implies government agency, government action. The police enforce the law. A prosecutor, may file criminal charges against somebody to enforce a law. But if we expand the definition to also include private parties and private actions, then I would have to say probably 98%, 99% of the quote-unquote enforcement actions would be by copyright owners. And they would use the DMCA based on a compliance process found in the law. So this compliance process was set up to try to informally address copyright infringement situations online and resolve them. And in exchange for this, copyright owners avoid having to go through the cost and expense of filing lawsuits. Websites and apps get immunity from copyright infringement claims based on content uploaded by their users, and the user gets a chance to realize that maybe they committed copyright infringement, didn't really know what they were doing. It was kind of an innocent situation, and they can get out of it. And so that's kind of how the DMCA works. So technically, if a copyright owner were to submit a takedown notice, then that would constitute, I guess you could say, enforcement of the DMCA. Now, all these areas get pretty dry, so let's use an actual situation, an example to try to keep it from getting incredibly boring. Let's say that Stephen King writes a new novel and that he uploads it and it's being sold online. Somebody purchases it and they purchase the ebook version, and then they convert that. They break the digital management rights on it. They break it, copy it, and then they list it on Amazon and start selling it, and they're collecting the money. Well, this would be kind of classic copyright infringement, and Mr. King would no doubt be very unhappy. And so he, or realistically his attorneys, would file a DMCA takedown notice with Amazon. And under the compliance process, Amazon would then immediately take down that listing, and they would give notice to the party who had put it up saying, hey, we received this DMCA complaint. You need to respond. And at that point, that person would either respond or they would just not, and the content would stay down. And so in that sense, Stephen King would have enforced the DMCA. There are also third-party services who will do this on behalf of copyright owners. And the reason for that is that somebody takes your content once and republishes it somewhere, they're probably going to do it multiple times. And if it's something that's popular, oh God, it's going to be all over the place. So instead of spending all of your time as a copyright owner hunting these things down, you can use a service for a small fee, and they'll go out and handle it. Some of these services are good, some of them are not. But that's a whole different subject. What about ISPs? So ISPs are the parties that are getting the immunity under the act. So in our example, Amazon, but it could be any website, any app, even the party you use to connect to the internet, Verizon on your smartphone or your cable company at home. As long as they comply with the process detailed in the DMCA, they have that immunity. And so do they actually go ahead and file lawsuits or try to take any action that could be considered an enforcement action under the DMCA? Not against copyright owners. I can't think of any kind of case, but I'm sure there's maybe one out there. That law's been around for 20 years, but extremely rare, if at all. However, one area that they do pursue what I guess could be called enforcement actions is against the actual parties, the users of their platform or service who receive complaints. So under the DMCA compliance process, and remember, these companies have to follow it to maintain their immunity, there's a requirement that each company establish and enforce a repeat infringer policy. And so this policy basically says that if a user gets X number of DMCA complaints within X period of time, then their account needs to be terminated. And so with YouTube, you're watching this on YouTube, they have a policy. I think it's something like 3 strikes in, 2 years, something like that. And that's a common standard use. It's pretty low. The numbers are pretty low. And so people get their accounts terminated all the time. And it's kind of ugly. But it is a situation that is required under the compliance process. So if an ISP was to shut down a user's account pursuant to the repeat infringer policy, I guess technically that would count as an enforcement of the DMCA. What about the users? What about the parties posting the alleged infringing content? Well, they have a right to counter whatever complaint comes in. And so they would have the right to essentially reply and say, no, I'm not infringing, and here's why. The other thing that they're allowed to do is in situations where the DMCA takedown notice is just incredibly obviously infringing, there would be an option for filing a counterclaim, if you would, in a copyright infringement lawsuit brought by the copyright owner, asserting as much. And I guess you could just file a lawsuit on your own based on that theory as well. And what you would have to show essentially is that there is no subjective basis on which that copyright owner could have thought that the complaint was legitimate. Now, again, that's subjective, not objective. So you're talking about what was the copyright owner thinking at the time. So the copyright owner only has to get up there and say, well, I thought it was legitimate, and you lose. So as you can imagine, very, very hard case to win. And that's why we don't see many of them brought. However, we have seen a couple in situations where it's just so obvious that the party who filed the takedown notice was wrong, that, the copyright owner's in trouble, to be quite honest. So I'll give you an example. In 2014, there was a case involving CrossFit. And CrossFit had served a DMCA takedown notice on somebody who had created a website with one of the free services, like either WordPress or maybe Blogger. So they had added the CrossFit name to the domain. So it was crossfit.blogger.whatever. And they filed a DMCA takedown notice. Well, the problem is that usage is not copyright infringement. It's trademark. It's a trademark issue. And with the DMCA, of course, it's Digital Millennium Copyright Act, not Digital Millennium Trademark Act. So they had filed the wrong notice. And I don't know why, but their legal department decided to take it to trial. And the defendant filed a counterclaim under Section 512F of the DMCA saying this is abusive. This is a trademark claim, not a copyright claim. This whole thing is basically out of line. And the appellate court who looked at the case agreed. They said that the user had a right to pursue, this abuse claim. And I don't know how the case resolved. I never heard anything more about it. So I imagine there may have been a settlement involved. But again, very rare situation. But it is possible that you could run into those kinds of situations. So, 1% of the cases maybe. So in summary, who enforces the DMCA? There is no government agency. If we're going to expand the definition of enforcement to include just, anybody asserting rights, it's going to be the copyright owner in 99% of cases, although there are going to be some situations where an ISP through the repeat infringer policy or a user who's dealing with a clearly abusive situation might take some action under the DMCA. So that's it for today's video. Thank you for watching. If you're interested in learning more about the DMCA, feel free to subscribe to our channel or hop on over and visit our homepage on YouTube, where we have quite a few other videos on the DMCA. We'll be covering just pretty much about every aspect of the DMCA anybody can think of. So hopefully you'll find it informative. Have yourself a good one.